All right, welcome to the program Left Right Radio with Chuck Morse every afternoon, 12 noon, Monday through Friday, Facebook Live and YouTube and all the affiliate stations. Andrew Torrez is my guest. He's an attorney. He's getting involved as a podcaster in liberal causes. He's a graduate of Harvard Law School. Andrew, thanks for joining me this afternoon.
Chuck, thanks for the invite. Glad to be on the show and looking forward to chatting.
All right, so we have obviously in the news from a legal standpoint, the nomination of Brett Kavanaugh as an Associate Justice of the U.S. Supreme Court. I think initially there was a lot of hoopla, some gnashing of teeth, as it were. But it seems to me that President Trump should be actually commended for choosing a fairly moderate to conservative judge. One, I think, cut of the same mold as John Roberts or Samuel Alito, less so maybe of a Clarence Thomas or of a Scalia. What do you think?
Okay, so I disagree with a number of statements in that. Let's kind of parse them out individually, right? So the first is, obviously, I'm a left of center guy. So if all we're evaluating is the outcome of a particular decision, that's not going to be a particularly useful metric, right? Like you've got a conservative president who's got 51 Republicans in the Senate. He can pass through somebody who's going to rule from the right. What I care about as a lawyer, as somebody who is a public communicator on these issues, is not what Justice Kavanaugh will do when he's confirmed to the Supreme Court. I believe that he will be. But my question is how and why, right? And that in the law is what we call jurisprudence. It's the theory of how you result in certain cases. And I'll tell you what I'm troubled by, right? I'm troubled by the fact that Brett Kavanaugh has said two different things to two different audiences about his jurisprudence, about how he rules on cases. So the first thing he said was in a 2017 speech to Notre Dame Law School. I've linked it off of my show, Opening Arguments. You can go there. You can read this for yourself. This was a statement to lawyers, and in particular aimed at the Federalist Society, which has been the organization that's been vetting Donald Trump's judicial nominees, right? And This is audition for being on the Supreme Court. He wrote this, gave this speech after Neil Gorsuch was nominated. And in it, basically, he says, hey, look, I'm just like Gorsuch. I'm just like Scalia. You can trust me and you can recommend me as a Supreme Court justice. And so in particular, when he's asked about his judicial philosophy, he says, I'm in the mold of a Scalia. And here's what he says, right? This is his actual words. I just want to make sure I'm quoting them directly. He says, so I'm the mold of Scalia. And here's what Scalia thought. He said, it's not hard. Judges should read the text of the Constitution as written, mindful of history and tradition. Okay. That's what he said to the Federalist Society. But when Kavanaugh was nominated, he said something a little bit different. He added two words. And, as a lawyer, like adding two words can be a big deal, right?
Oh, sure.
So he said, my judicial philosophy is straightforward, and a judge must interpret the Constitution as written, informed by history and tradition and precedent. And in my
that's
view,
the key.
Those last two words are the key, right? And my question for Kavanaugh, and again, I want to evaluate this. My question is, what's the role that precedent plays in your judicial decision-making? Because Antonin Scalia did not care about precedent. Antonin Scalia was utterly unconstrained. If there were prior Supreme Court opinions that differed with his view of what the text meant and what the Founding Fathers meant, then he felt confident in disregarding those opinions. I think that's dangerous on the court. I think, I'm coming from the left, but I view this as a mainstream and conservative with a small c judicial philosophy. I think we need to constrain the power of judges. And one of the things that constrains the powers of judges is having prior precedents, having prior cases that you have to deal with. And I deal with this on my show all the time, right? In 2021, President Elizabeth Warren is going to nominate someone to the Supreme Court, and they're going to be stuck with precedents from the past 10, 20 years from a very, very conservative Supreme Court. And I think we need to be careful before we're just willy-nilly disregarding precedent. So there's my case. That's what I'm looking for from Kavanaugh.
Very interesting. I think that we have definitely a difference in terms of how we would define the role of judge with regard to precedents. I would view the appropriate function of a judge to not make things up from the bench, but to
Sure. Okay. Well,
Well, wait a
Can
minute.
we talk about what
We can, but I just want to finish my thought. Take a look at the Constitution as the primary focus of their judicial decision, because that's what the Constitution is. It prescribes to the Supreme Court in Article 3 the certain particular functions. Now, Judge Kavanaugh, of course, has a long record. He's for 12 years on the bench of the D.C. Circuit Court of Appeals, which has been described as the second most influential court in the country. And he's written over 300 decisions. So I think that, we can take a look, and I'm sure that it's been gone over with a fine-tooth comb, actually, what his decisions are. And it seems to me at just a very initial glance as someone who's not a lawyer and who's just looking at this thing from very conventional, superficial sources, that he does tend to rule on issues across the board. I think that he does consider precedents, but he also holds as the primary focus the U.S. Constitution. Obviously the big hot potato in the whole thing is Roe versus Wade, how he'd rule on that. He has been on the record as saying that he's not going to overrule it, according to his Wikipedia page. I don't know how reliable that is, and I'll grant you. But he's on the record as having said that, again, according to them. But at the same time, as a conservative judge and as someone who does look at the Constitution, I think that he's going to not expand Roe versus Wade. So on the one side, on the left, you have people who want to expand those powers, and on the right, you have people who want to rescind them. I think that somebody like a Kavanaugh and probably most of the other judges on the conservative side would fall in the middle on that, in that they would preserve the actual language of Roe versus Wade, which if you read that decision is actually fairly restrictive, and not see those precedents expanded, putting aside the actual constitutionality of that decision.
Okay, an awful lot there, and I really appreciate that. We're going to kind of go back and forth. I don't want to talk over each other, but you made about 3 or 4 points in that last block, and I want to kind of tackle all of them individually. Right. Sure. The first is so Roe v. Wade. I may be unique on the left on this. I am less worried about Roe v. Wade. I think that John Roberts is probably going to craft some sort of compromise, because Roberts is more of an institutionalist, cares more about precedent, cares more about stare decisis than I believe Brett Kavanaugh does, certainly more than Neil Gorsuch, Samuel Alito, Clarence Thomas. I think you have 3 to 4 hard votes for overturning Roe right now. I think because of John Roberts' personality, I think he's likely to scale it back, but still, reaffirm the central holding. I am far more concerned with the Supreme Court's decision in Obergefell versus Hodges, the gay marriage decision from 2015, because there's a much narrower window of time, and you have a Supreme Court just this term in a case called Janus versus Asked Me. There's a little bit of a rabbit trail we need to go down, but they overturned a 40-year-old valid Supreme Court decision for no greater purpose other than the 5-justice majority, joined by Anthony Kennedy, disagreed with their rationale from 40 years ago. They were utterly unconstrained by precedent. So let's talk about, I think what I would like to go back to, so I want to put a pin in that, because I want to talk about Roe and in particular the aftermath, Planned Parenthood versus Casey, because that is, in my view, the landmark test in the modern era of the value of stare decisis, right? But I want to go all the way back to the first thing you said, right? Because I hear this a lot from voices on the right, and I want to test what this means. You say, I want a judge who follows the Constitution. Right? Yes. It follows the text of the Constitution. So do I, right? As you know, Article 3 of the Constitution is very, very short. It doesn't specify the lower federal judiciary, the circuit courts of appeal. It just says the judiciary shall be vested in one Supreme Court, right? And so to figure out what Article 3 means, we look at things like, say, Federalist Papers, Federalist number 78, which was written by Alexander Hamilton, no liberal. And in fact, I am going back and I'm looking to, right, all the things that Judge Kavanaugh says he values, right? History, precedent. Here's what Federalist 78 says. He says, this is Hamilton writing, he says, the complete independence of the courts of justice is peculiarly essential in a limited constitution. Limitations of this kind can be preserved in practice through no other way than the medium of courts of justice, whose duty it must be to declare all acts contrary to the, and this is the important phrase, manifest tenor of the Constitution void. Without this, all reservations of particular rights or privileges would amount to nothing. And so what you see in the Constitution, you don't see a lot of specific, easy to understand language, right? There's a little bit of that, right? The president must be 35, right? So if a 32-year-old tries to run for president, there's no interpretation, there's no intent. You're not 35. The Third Amendment, right? You can't quarter soldiers in people's homes. All right. Do you stick a soldier in someone's home? That violates the Third Amendment. Do you not? Okay, it doesn't. But the rest of the Constitution, and that's why there's no jurisprudence on that, right? And there was some crazy, oddball liberal article that I debunked on my show, right? I go after the left plenty of times. I debunked it on my show that was trying to argue, well, the Third Amendment might apply to FISA courts and surveillance. And it was garbage, right? The Third Amendment does not enshrine a principle. It defines a specific practice. But I would ask you,
if I might interject here, what about the 9th and 10th Amendments, which particularly
we can go there?
Yeah, I mean, it basically says that all power is not specifically delineated to the U.S. Constitution, and the federal government shall reside with the states and with the people.
Right. And there's a complex history on 9th and 10th Amendment jurisprudence. We can absolutely get there, but I'd like to go back to your point first. So let's do that. What I see in the Constitution is I see phrases that have general relative applicability as enshrining certain moral principles into the law. So, for example, the Fifth Amendment says no person shall be denied life, liberty, or property without due process of law. So you might ask, what's a process and how much of it are you due? A really obvious example is the Eighth Amendment that prohibits cruel and unusual punishment. So let me try and ask you this. What do you think the Eighth Amendment means? What would, under your view of jurisprudence, what is a judge looking at the Eighth Amendment to say, what does that mean?
I would probably look at the writings at the time, at the debates in the Constitutional Convention, the letters between Jefferson and Hamilton being the father of the Constitution and the Bill of Rights. And I would try to see what did they mean by cruel and unusual punishment. Rather than simply making it up now. I mean, and also, yes, precedence is a part of it. Case study is a part of it. There's no question about that. I mean, it doesn't exist in a vacuum. But you don't want to have somebody who simply pulls something out of, claims that there are penumbras and emanations and that kind of thing. You want to take a look at what's both there, but also what's the spirit of it at the time. And I think it was it Madison or was it Jefferson or someone who said that the Constitution at the same time is not going to be a straitjacket. It has to essentially be flexible enough to respond to emergency situations as they might arise.
Yeah, I think you're talking about the 20th century case in which it might have been Oliver Wendell Holmes. I forget who said the Constitution is not a suicide pact, but
That's right.
But let me piggyback on what you just said. So I don't think we're that far apart, left and right. So you started off with, I think, as a good Scalia answer, that cruel and unusual punishment means what the framers wrote in 1789. So you'd ask yourself, was a punishment considered cruel and unusual in 1789? If yes, then it's prohibited. If no, then it's permitted. And the problem with that, and Antonin Scalia was asked about this when he was on the court by Nina Totenberg in 2004, I think. The problem is our founders permitted the stocks, public flogging, breaking on the wheel, things that are very clearly torture. And if any state in the union decided to bring back the stocks right now, you would instantly have a lawsuit. And I believe even this Supreme Court would have no difficulty saying, no, look, like public execution, torture, stocks, breaking on the wheel, that's cruel and unusual punishment, because that's what that phrase means. Because the question is not, and this is where we differ, right? You think, or what I've heard you articulate is that the opposite side is just making it up. And my view is absolutely on the left. If there's anybody that wants to just make it up, I wouldn't want them on the court from the left, right? And so, for example, there is a far left judicial school that is called Critical Legal Studies. It is led by Roberto Ungert. They believe in a neo-Marxist Marxist application that says the law has no fixed meaning and we're all just making it up, so let's make it up in order to benefit the left. That's being uncharitable, but I'm not a critical legal studies scholar, so I can criticize the left. Right. And somebody with that view would not, in my view, be eligible to serve on the Supreme Court. Right. What I am arguing is that when you have that same view on the right, when you are utterly unconstrained by precedent, you are similarly precluded from serving on the Supreme Court. And my argument on that, and again, the Democrats botched this in 2017, is Neil Gorsuch. And I can tell you, I was, as far as I know, the only person out there, you can go back, it's Opening Arguments episode number 40, in which I said the problem with Neil Gorsuch is not the stupid ICE trucker argument that the Senate Democrats made that lost them Heidi Heitkamp and it lost them Joe Manchin. It is that when Neil Gorsuch was on the 10th Circuit Court of Appeals, right, when he is obligated to follow Supreme Court precedent because they're his bosses, right? There's vertical precedents there, right? Sure. Literally 5 months before he was nominated by Donald Trump to the Supreme Court, he wrote an opinion called Gutierrez-Brizuela versus Lynch. And it had to do that the merits are not particularly important, but it had to do with how administrative agencies apply their interpretation of a statute, right? And in that opinion, again, I can give you the citation, you can look it off the page, you read it for yourself. In that opinion, at the end, Neil Gorsuch openly muses and says, I would sure love to be on the Supreme Court because I have to follow this case called Chevron versus National Resource Defense Council, and it's a terrible case, and I can't wait to overturn it. That's unprecedented for a circuit court judge to say, you should elevate me to the bench so that I can take a 1984 decision and reverse it. And by the way, Chevron, 1984 case, right, that's a pretty conservative Supreme Court ruling for Ronald Reagan's Environmental Protection Agency on their interpretation of how to carry out the authorizing statute on the EPA. What Reagan's EPA wanted to do, that was Neil Gorsuch's mom, Ann Burford.
Yeah, that's right.
They interpreted the EPA's mandate as allowing them to engage it, to basically to scale back on regulations. And very liberal groups sued and said, no, you can't do that. And the Supreme Court, in an opinion written by John Paul Stevens, not controversial, left and right across, ushered in an era of what they called Chevron deference with this decision, 1984. And they said, look, unless there is if there is an ambiguity in Congress's deferral to an executive agency of the scope of its authority, then what we as a court do is we don't get to just make it up. We are confined by what the administrative agency determines that its authority is. We defer to it. That's why it's called Chevron deference. It's a limitation on the power of the courts, right? And it is putting power in the hands of the people, in the hands of the executive and the legislature. And Gorsuch said, no, I want that power for the courts. I want us to review de novo. And that's the direction the courts are going. And Kavanaugh has in that same 2017 speech, endorsed Gorsuch's view on Gutierrez-Brizuela versus Lynch. So that's another area where I think he is just unconstrained in terms of being able to make stuff up on the right. I don't want judges making stuff up on either side of the aisle.
Right. Okay. Let me just, again, from my non-lawyerly perspective here, let me comment on two things. Firstly, on the issue of the cruel and unusual punishment as meant by the founders of the Republic, I suppose technically the states could put back stocks if the people of that state and the legislatures decided to do that, and they elected legislators to vote for a bill like that, and the governor approved it. But the fact is that mores being what they are, that's not going to happen. Just like, in a sense, the states technically can have a state religion. And many states did right up until the 1830s. I think the last state to get rid of their state formal religion was New Jersey. And I believe it was in 1838, around that time. But technically they could do that. But the fact is our society has moved in a direction where that has been dismantled. I mean, I can give other examples. Public voting, that was gotten rid of in favor of the private ballot. Technically, the states could do that. But the fact is, but the fact is that mores being what they are, people aren't going to elect a legislature that will put in those sorts of laws because it's just no longer seen as something that's beneficial. Now, I just want to briefly respond to the second thing, which is the Chevron case. I don't know the case specifically, but from what you're telling me, what I gather in terms of Gorsuch's objection to that case, and probably Kavanaugh's as well, is that you have a situation where a federal agency, in this case the EPA, is basically expanding its original mission and purview by making laws, or what they call, quote unquote, directives or guidelines. They give them different names. And that it is outside of the original mandate given to it by the Congress when they passed the law that set up that agency. And that this is a problem that's been brought up by President Trump. And he's referred to it as the administrative state. Steve Bannon, the former advisor, famously said that the main crux of the Trump administration is going to be to dismantle the administrative state. And by doing so, returning legislative powers back to the people and their representatives in Congress and in state governments. And I think that, again, I haven't read the case, but I pretty much can guess that that is what Gorsuch is objecting to. Not activist judges coming in and making laws, but judges saying that the Congress is to make the laws, not these unelected bureaucracies who are taking on sovereign powers.
Okay, so let's work backwards from that. That's an absolutely correct political statement that Donald Trump and I don't mean this derogatorily, insultingly. I would say it is an extreme far right position, right? In the sense that there are many conservatives on the objection on the administrative state, right? Because there are many conservatives that don't share in that objection. So I'm defining it precisely. Not trying to do it as an inside. I'm coming on to
no, I'm trying to embrace that. Yeah.
Yep. Okay.
If you must.
So it is absolutely a political cause, right? The question is, how does that overlap with your jurisprudence? Can you use the courts to achieve that result? Okay, and let me dig down on both elements of Chevron. So number one, Chevron deference does not apply if the grant of authority from the legislature to the executive agency is explicit. If there is no ambiguity, nobody gets to decide anything. It's unambiguous. It is in the hands of what the legislature gives as power to the agency. So that handles, I think, the democratic aspect of it.
Well, let me ask you this: the Chevron piece, did the EPA go above and beyond their original mandate as granted them by Congress?
And that gets to the second part that I was going to say, which is that's always the allegation, right? When you have, as in 1984, when you have a Republican agency doing something liberals don't like, they file a lawsuit challenging the agency's use of its authority. When you have, as under the President Obama, when you have a Democratic president and Democratic executive agencies, then conservative groups challenge what the executive agencies are doing as not being authorized by Congress. The really important question here is who gets to decide if there's an ambiguity, right? So the answer right now, and I believe the correct legal answers are, who gets to decide? Number one, Congress gets to decide. If Congress makes it clear your agency can do this but can't do this, that settles it. There's no court case, there's no nothing. Congress decides, it's in the hands of the people. But number two, if it's ambiguous, then the question is, do we let the courts decide that de novo? Do they get to make it up based on their view of how they read Congress's delegation? Or do we defer to what the agencies say about how they have historically interpreted this mandate and how they apply that presumption? And my argument is, yes, it concentrates some delegated power in the hands of the executive agencies, but it is a far greater abuse of power to allow judges to come in and say, as a matter of first impression, I'm going to say your agency's determination of the grant of its authority is improper based only on what I, Neil Gorsuch, think the law is. I think that's too much power in the hands of the judiciary. And I think if you want to accomplish, awesome, that's fantastic.
No,
so that's what I want us to look at. Oh, I'm sorry. I thought you said I don't disagree.
No,
okay,
I totally do disagree with that. I would rather see the courts decide, both on the federal and state level, whether or not an agency like, well, let's say the FBI, let's say the NSA, we can name any federal agency, if they are exceeding their powers, I would want to see the proper check and balance to that power grab. And I think the proper place for that is first Congress, but if they don't do it, then the judiciary. Yeah, those agencies they do not have governing powers. Those are subsidiaries of the executive branch. They are given certain very prescribed responsibilities. They are directly under the auspices of Congress. They have to testify before Congress. It bothers me, for example, that you've got an FBI now that's refusing to release information to a congressman. That's contempt. They should be put in chains and taken away and put behind bars. Who are they to tell a representative in Congress elected by the people that they're not going to release information? I mean,
okay, well, that's a rabbit trail we're not gonna go down. Okay. But let me ask this question, right? I get that you would like to curtail the power of administrative agencies. So would Neil Gorsuch. My question for you is, consistent with how we began the show, where's the constitutional mandate? Where's the Article 3 mandate? Where are the discussion in the Federalist Papers that gives the power to the judiciary?
Article 1, Section 8. The first
Article 1, Section 8 does not grant any powers to the courts. Article 1, Section 8
to Congress. It says Congress shall make the laws. Congress.
Right. So,
and the courts are there to interpret.
I totally get it. I totally get it. And we're in agreement on that.
The IRS doesn't make the laws. They don't decide which group gets tax exemption and which doesn't. It's Congress that makes the laws.
I totally agree.
And if they want to defy Congress, they should be in jail.
Same question, though. Where in the Constitution, where in Article 3, where in the history of the Constitution, does it give the courts the power to determine when Congress has appropriately delegated authority to an executive agency or not? It's not there.
Marbury versus Madison set the precedent.
Marbury versus Madison is judicial review. I love Marbury versus Madison. That's right.
I do. Well, I don't love it because of today's characters. Some of them are less patriotic than John Marshall was. But the point is that what that says is that the Supreme Court took its position early on as the reviewer of laws, judicial review. They get to take a look. Totally. This is exactly what I'm arguing for. The judiciary, whether it be the Supreme Court or federal courts, they get to take a look at agencies of government that are trying to behave above and beyond their purview, and they do get to curtail it. If they don't, then who does?
But that's what the Chevron. But that's what the Chevron case does, right? I'm not saying the judiciary doesn't get to review it. Like, I'm very pro judicial review. That's my whole point of being here. What I'm saying is, does a Supreme Court, untethered to prior precedent or administrative determinations, get to just make up what it thinks Congress meant to delegate, or does it have to follow the appropriate steps? Does it have to say, number one, is this an ambiguous delegation? Okay, it's not ambiguous, we go with Congress. It is ambiguous, we defer, we don't rubber stamp. There are plenty of cases of Chevron deference where they look at the administrative agency's determination and then say, but that's not consistent with the law. That's what judicial minimalism means to me, right? Look, I'm not, again, Chevron was about Ronald Reagan's EPA curtailing the Clean Air Act, right? I am politically opposed to it. But as I started off this show with, I don't just want to remake the court to have more people who vote my way on that court. I am concerned with how the court makes decisions. And I am very, very concerned that you have an extreme right-wing cause, dismantling the administrative state. I want you to go ahead, win in the right, win democratically, right? If you can convince people that Congress ought to constrain itself in how it delegates authorities, by all means, go for it. I don't think you will, because I don't think the public's with you. But I've been wrong on stuff before.
No, it's not a matter of Congress. It's a matter of the agencies, the transfer of congressional power to these unelected
Congress
instantly, I don't think anybody
instantly could attach to any bill. They could say, here is the scope of the delegation of authority. It doesn't exceed X, Y, or Z, and no interpretation of the contrary is valid. That's not hard to do. You could do that democratically.
Congress has surrendered aspects of its own constitutional powers. And look,
but Congress can always reclaim, but they can always reclaim.
They can, and they ought to. But if they don't, then you have a rogue agency. And I'm not an
No,
anarchist.
not true.
You
Not
mentioned
true.
you
Not
mentioned
true.
Alexander Hamilton. He's the one that found in, I don't know if he found it in the Constitution, but he's the one that found, quote, implied powers as his argument to set up the first bank of the United States, which is not in the Constitution. So I get the fact that, this can be done in certain circumstances. I'm not opposed to that. But the point is that conservatives generally view it as having gotten way out of hand, way out of control, especially with the transfer of powers. I mean, we could go into many examples of where Congress has surrendered its constitutional powers. What about the power to declare war? Congress has surrendered that to a certain extent to groups like NATO and the United Nations and other international agencies made up not even of American citizens. So, I would rather see a check and a balance on that by a judiciary that takes a look at the Constitution and says Congress is in. Because Article 1, Section 8 says Congress shall make these laws, including the declaration of war.
Okay. That again, I don't really know down that rabbit trail. I would certainly argue that domestically Congress has ceded considerable power to the executive branch, particularly post 9/11, in terms of allowing the executive to act unilaterally. I agree with respect. I agree with respect to force determinations, the 2002 authorization for the use of military force. So maybe we're on the same page with respect to that. But again, I want to go back to the underlying principle here, which is how I am arguing for a small c conservative court. I am arguing the principle that I thought you were taking from the beginning, which is regardless of whether the justice is left or right, I want that judge's obligations to be constrained under the law and to not be able to remake the law wholesale to comply with his political or her political leanings. And what I've laid out for you here is I get that your goal is to dismantle the administrative state. Neil Gorsuch put that in writing. My goal is to dismantle the administrative state. What I'm saying is that should be done politically. It should be done through the elected process. And if you don't get all the way there, if Congress doesn't agree with you, you shouldn't resort to the courts to clear up the problem or to speed that along. You should win it fair and square. Let me ask you another question, right? So as long as we're talking about state powers, let's talk about another activist decision, right-wing activist decision, Antonin Scalia's opinion in the 2008 DC versus Heller case. So as you know, prior to DC versus Heller, the Supreme Court had never in our nation's history struck down a law prohibiting the ownership of one or a class of firearms on the basis of the Second Amendment. And this was something that was, in general, left to the states and left at a pretty good clip, right? And so there was a 1975 gun ban in the District of Columbia. And you know what? DC is a really liberal place, right? And so if you wanted to own a handgun, you lived in Northern Virginia, right? Even if you worked in DC. You didn't have to live in DC. You could lobby people in DC to try and change their gun ban. And look, like that works sometimes, right? Like Vermont is a super crazy hippie liberal place and they have no gun control legislation, right? But instead, what conservative activists did.
In the country, by the way.
I'm sorry. Yeah, exactly. Right. So look, and I'm not a huge, I'm picking this again as a process example. I'm not a huge gun ban guy, right? But what I'm saying is that in the late 2000s, what conservative activists did was say, you know what, we're not winning everywhere. We haven't convinced people in DC that gun bans are bad. We haven't convinced people in my own state of Maryland that gun bans are bad, and 15 other states. So we're going to go back to the court. We're going to take a 30-year-old law on the books. Everybody knows what it is. Everybody knows how it operates. Everybody knows you can't carry a handgun in the District of Columbia. And we're going to challenge it because we think we have a more conservative Supreme Court now, and we think they're going to rule in our favor, and we think we're going to get a victory in the courts that we can't get in the legislature. What do you think of that?
Well, I think that did this just apply to DC, or was it brought on the part of a state? Because
so
I think
Yeah, no, that's a really, really good question. It actually brought up your previous point with respect to what the states could do in the 1830s. Prior to the 14th Amendment, right, which is passed in the late 19th century, the Bill of Rights was not incorporated to the states. So that's how states could have an established church. obviously violates the First Amendment. First Amendment didn't apply to the states back then because the First Amendment says Congress shall make no law. And until the 14th Amendment said no state shall deny to any person in its jurisdiction equal protection of the law, those protections in the U.S. Bill of Rights did not apply to the state government. You could have an overarching state government that intruded upon your liberty, and you would have no recourse at federal law. I think it's an unambiguous good thing that the 14th Amendment incorporates those provisions of the Bill of Rights to the states. And so DC versus Heller tested the first part of the question because of the unique status of DC. It directly applied the Second Amendment. And then after DC versus Heller, the Supreme Court in a 2010 case, it was, I think it's McReynolds or McDonald, Gregory versus McReynolds or McDonald, then incorporated the DC v. Heller ruling, which applied narrowly only to the District of Columbia, and incorporated out the Second Amendment to the states. So now that is law, right? That is, the Second Amendment is interpreted via DC v. Heller as prohibiting any state in the union from prohibiting a class of ownership of handguns, right? There are some other cases, like the Colby v. Hogan case in the Fourth Circuit, upheld Maryland's semi-automatic assault weapons ban. So it's unsettled at this point. But nevertheless, like, the Supreme Court absolutely, in an activist way, went and changed 200 years of jurisprudence in order to reach what I can tell is a result that conservatives wanted. And that offends.
Okay.
That should be up to the states.
Again, I don't know the details of it. My suspicion is that it had to do with an unprecedented expansion by the federal government itself in the area of gun control over the states. Now, DC is not a state, that's a federal district, so it's a little bit different than the federal government taking an overarching hand in gun control in the states. And I think that it's...
And again, just from a historical perspective, not true. The immediately prior case was Miller versus United States. It was a 1938 case, I believe. And it was about the government at that time banned sawed-off shotguns. And they banned sawed-off shotguns.
And they banned automatic weapons.
Right? Yeah. But sawed-off shotguns are not automatic weapons. They banned them because they were the tools of bootleggers during Prohibition. And the Supreme Court said in 1937, 38, I could be getting the date wrong, in Miller v. U.S., said, you know what? Sawed-off shotguns are not the kind of weapon that is useful to a militia, and therefore it is not within the class of behaviors that the Second Amendment was meant to protect. Right, it was meant to restrain against, and so therefore, and again, we have both an originalist view and we have a pro-democratic view. What the Supreme Court said was not like, hey, nobody anywhere gets to own any guns. That would be liberal activism. It would be terrible. What the Supreme Court said was what we then saw, which was, hey, solve this politically. Right? Reasonable people can disagree about whether you ought to own a handgun in a certain jurisdiction. Reasonable people can disagree about whether banning handguns is a good idea or a bad idea, right? Like, the history in DC is probably not a fantastic argument for banning guns, right? But it's up to the people. It's not up to Antonin Scalia to come out and say, nope, sorry, these laws are no good now. Do you agree?
Well, I think that the spirit of what, again, I didn't read the decision, but the spirit of what Antonin Scalia was saying was that in favor of the right of people to own guns, not taking them away. Now, look, I think that both sides can make the argument that the Second Amendment can be interpreted in such a way that, the Founding Fathers didn't have assault weapons in mind. I mean, they didn't exist back then. Do we want to have people have a nuclear bomb in their backyard? I mean, of course, there was a point of regulation, and that's a reasonable thing. And I think that people on the right often go too far off in the extreme on that one. But
fantastic. But I'm not, again, I just want to go back to my central premise, right? Which is, yes, if you want to say something is a core right that is clearly protected by the Bill of Rights, then I agree. We take that out of the majority's hands. Right? If a state wants to require that everyone within the state be Christian, right, that plainly violates the First Amendment. That's an establishment.
Let me just interfere. Right? Nobody said. I think that these state laws recognizing a state church didn't require everyone to be Christian. All it was. And I also don't necessarily agree with you that the 14th Amendment would supersede a state doing that. It hasn't been tested. But
Well,
it's a moot
it's
issue
been tested for
because
a century, right? Like, I mean, this is another one of the.
it's never been tested because all the states got rid of that before the 14th Amendment. But the point is, there's no move to bring that back. Nobody wants that. It's not something that's on the table.
That's not what I'm trying to get to is that when you have a clear right that is being violated, we take things out of the hand of the majority. But I think the small c conservative principle is if you don't have that, then it ought to be up to the people to decide. It ought to be up to the democratic process to figure out if we want gun control laws. Let me give you something, and I'm deliberately going to push you a little bit on this because I know your background, I know your award from the Right to Work Coalition, but the Supreme Court's decision in the Janus versus AFSCME case strikes me exactly the same way, right? So you had 40 years ago, the Supreme Court answered the question of whether unions could have an agency shop, right? That is, you can't force everybody to be a member, public sector unions, teachers unions, government employees unions, right? 40 years ago, the Supreme Court looked at it and said, hey, you cannot force people to be a member of the union. You cannot force them to sign on to your political activities. That violates the First Amendment. But under the NLRB, the National Labor Relations Bureau, right, and the National Labor Relations Act, the public sector union is required to negotiate on behalf of all of its members, right? Even the ones that opt out from the political process. And so it's reasonable for them to impose, and let's be 100% clear on this, the administrative, non-political, non-speech component charges of their activities. That is, going out and getting raises for teachers or working conditions, right? It's reasonable for them to impose that on the entire membership rather than allowing you to opt out. That's what the Supreme Court said in a case called Abood versus Detroit Board of Ed. And again, the basis for that is your teachers union can't go up and say, we want a 5% raise for unionized teachers, and those non-unionized teachers can, go pound sand, right? They have to negotiate for the entire class. So the question was, could they pass those costs on to the entire class, or did everybody get to opt out? Do you get the free ride? You say, hey, I'm not paying any dues to the union, but I'm happy to have them negotiate my 5% increase, right? And the Supreme Court said they can do that, right? That they can pass on those administrative costs, okay? And in response, people on the right, people like you, were able in 28 states to get right to work laws passed, right? And again, we could debate we could debate whether that's a wise policy or not, but that was the situation we had. 28 states, right to work laws that prohibit that practice, that say, nope, you can't impose even the administrative costs. 22 states covering 5 million employees and the District of Columbia that said, yeah, no, you know what, we tried, we heard those arguments, but we're coming out the other way. We're saying the unions can do that. Exact same thing, exact same situation, and same thing happened in 2017. Right-wing activists were like, hey, we're going to get a guy who's going to go to the Supreme Court. We think the court's more conservative now than it was in 1977. And the Supreme Court overturned the Abood decision and just said, no, we don't like that. We thought that decision's not well-reasoned. So we're not going along with that anymore. And crucially, what that does is that converts all 50 states into right-to-work states for public sector unions. It took the choice out of the hands of the public. Doesn't that run you? Wouldn't you like to win the right way? Wouldn't you like to convince people in DC and Maryland and Michigan that they ought to change their view on unions rather than have the court dictate that? That's my view.
Now, you know a lot more about the history of this than I do. My impression was that public unions were not really a part of that decision. It had more to do with the AFL-CIO, that public unions actually didn't really come into existence until the 1960s under the Kennedy administration. And at that point, the National Education Association, which was not a union, it was an association, really didn't become, in the formal sense, a union until that time. And there are serious constitutional questions about whether or not there even should be public unions. This is not the private sector. This is not a corporation where people have the right to organize and redress grievances, and they have a right to collective bargaining because that's a basic right of assembly. This is public sector employees who are paid by taxpayers who, while they certainly have a right to assemble and they have a right to form associations, do they formally have the right to negotiate, to bargain collective bargaining and whatnot, using public funds to do so because that's how they're paid? And do they have a right to take a portion of their public funds to support candidates who will then be elected and further support their positions? Those are the.
But again, that second half, the Supreme Court has very clearly said no. Right. The second half, the Supreme Court has said you cannot take involuntary contributions and spend them on political expenses. So there's no issue with respect to that. The issue on, if you want to debate the constitutionality of public sector unions, we could have that. But that's not what this case was about. This case said, given that there are public sector unions, and given that we decided 40 years ago that public sector unions could charge their administrative, non-political expenses to the entire membership class, the question is that still good law? Do we want to take another whack at it? Are we willing to put this into the category? And again, let me be clear about this. Prior to this Supreme Court, what it meant to overturn precedent was that something was so historically awful as a decision that it rose to the level of Plessy v. Ferguson, right? Brown versus Board of Education was squarely an issue, right? And again, this goes back to the originalism argument, right? It was clear the authors of the 14th Amendment did not intend for that to desegregate schools. They intended for it to be separate but equal. And then 50 years later, the Supreme Court said, you know what? Separate is inherently unequal. We were wrong. We made a mistake. And this is a terrible, catastrophic mistake. And we're willing to overturn that in these very extreme circumstances where it is a catastrophic error. So I look to, when I think about what should that threshold be, right? I clerked for a very conservative judge on Maryland's state Supreme Court. It's called the Maryland Court of Appeals. His name was Lawrence Radowski. And he used to say, I only dissent in cases where I can literally taste the bile in the back of my throat, right? If it's just here, I'll let it go. And so I like to think of that statement kind of writ large when you think about, should the Supreme Court reverse prior precedent? And I look to, again, a conservative case written by conservative judges in 1992, Planned Parenthood versus Casey. It drastically curtailed the scope of Roe v. Wade, right? It changed the trimester system to an undue burden test that allowed for an awful lot of regulation in the first trimester that was prohibited by Roe v. Wade, right? But in that case, the central holding was Roe v. Wade remains good law under the principle of stare decisis, under the principle of following precedent. And our tests for whether something ought to be respected as stare decisis is, has the central rule in that case been found manifestly unworkable? Could the rule be removed without reliance, expectation, interests being adversely affected? Is the rule itself an anachronism now? Is it so far removed from where we were when that rule came out that it's just not reflective of modern society? And have the facts so far changed as to render that central holding unjustifiable? So to me, that's a high bar to clear. I would support the Casey bar in terms of when you overturn precedent. And I think what we're doing is backing away from that. We now have a Supreme Court that says, I don't like Abood. I hate unions. I think this is a problem. I'm going to overturn a 40-year-old decision.
Again, it's public unions we're talking about. And there are, again, serious constitutional questions about double jeopardy with regard to public unions. But Andrew,
I'm sorry. Wait, what is that? I don't.
No,
if we're done, we'll do it some other time. That's fine.
Yeah, we'll do it. But we're talking public unions, not unions. Anyways, Andrew, listen, we're reaching toward the end of the.
Yeah.
Right, which I think actually is not activist. We're reaching toward the end of the program here. I really enjoyed the conversation. I'd like to do it again. Talk a little bit about where I know that you're a podcaster. Where can people watch your podcast, get more information about you?
Hey, thank you very much. I appreciate the plug. So my show is called Opening Arguments. If you do a Google search for Opening Arguments, if you go to openargs.com, you'll find us. We're a pretty big show. And the idea is we pair, my co-host, Thomas Smith, is a non-lawyer, ex-accountant. He's been podcasting for 10 years. He is like a 30-year-old Larry King. He is the best interviewer I know in the business.
I like Larry King.
Larry King very famously said, I don't read your books coming in. So he is a non-lawyer, right? And so what we do is we take stories in the news that have a legal component and we try and break them down so that you get the actual facts. We call it opening arguments. We're totally clear where we are left. We're left of center.
Right.
But we call out. You've been through my archives, so we call out fake news on the left. There's not as much of it as there is on the right, but we call it out when there are misconceptions. Yeah, I know you do. We'll have to get that some other time.
But you're left, but you're rational. I mean, I've noticed this. And by the way, Larry King's great strength was that he would toss out these what seemed like a softball, and he would bring someone in. He'd make them feel comfortable. And they would end up talking about a lot more than they would have talked about if he came at them with both fists. And it was a great skill. Anyways, Andrew, listen, thanks so much for joining me. It's been a great pleasure.
Yeah, thanks for having me on the show.
All right, take